If you believe that you were the target of protected class discrimination, or you believe that you were fired because you engaged in legally protected activity, there are a few things that you need to know. I'm attorney Laura Schultes with RSH Legal. Are you an Iowa employee who has recently been terminated and believe it may have been an unlawful termination? Of course, not all terminations are unlawful. Often, even a very unfair termination in Iowa isn't against the law. That is because Iowa is an at-will employment state. Unless you have an employment contract or you benefit from a union collective bargaining agreement, you are likely an at-will employee. That means you can quit your job at will, but it also means that your employer can fire you at will. However, even at-will employees have legal rights. While employers are given a lot of discretion to make hiring and firing decisions, even unfair ones, there are certain reasons that a firing might cross the line from unfair to illegal. For example, both Iowa and federal law prohibit certain types of discrimination in employment decisions. These laws prohibit employers from discriminating against employees because of their membership in the following types of protected classes: race, color, sex, religion, gender, age, disability, national origin, or sexual orientation. These laws also make it unlawful to retaliate against an employee for opposing discrimination or harassment that is related to those protected classes. Another type of unlawful termination may involve a situation where an employee participated in what the law deems protected activity, and then the employer terminates the employee because of that protected activity. This might be the case where an employee is fired for something like reporting a work injury or pursuing workers' compensation benefits, complaining about a clear workplace safety violation, or even making a complaint to OSHA, engaging in legally required conduct, such as mandatory reporting, reporting illegal activity, or participating in the investigation of illegal activity. For an employee's activity to be considered legally protected from retaliation, there must be a clear Iowa statute or regulation that addresses the behavior that the employee engaged in. If you believe that you were the target of protected class discrimination, or you believe that you were fired because you engaged in legally protected activity, there are a few things that you need to know. The first thing to know is that there are legal deadlines that you have to meet. Generally speaking, the deadline to bring a claim for unlawful protected class discrimination is 300 days from the discriminatory act. Other types of unlawful terminations, including those based on protected activity, have a longer deadline, but you still must generally take some type of legal action within 2 years of your employer's unlawful conduct. Determining the right deadline is not always a straightforward task, and the sooner you consult an attorney, the better. Second, not all claims are lawsuits right away. For example, cases involving protected class discrimination and harassment have to first go through an administrative agency, such as the Iowa Civil Rights Commission, or the EEOC. Other types of unlawful terminations can be filed in state or federal court right away. An experienced employment attorney can tell you which path your case may need to follow. Third, regardless of where you have to start your filing, you will need evidence to support your claims. Oftentimes, your employer is the one who is in possession of the most useful information, and you may need an attorney or even a court to get that information. However, you should collect what you do have access to, such as your personnel file or any performance evaluations that you might still be in possession of. Important documents and records, including performance improvement plans, disciplinary write-ups, and written termination notices. Any notes, emails, voice recordings, or other tangible evidence from important meetings or conversations. Employee handbooks or policies that were given to you by your employer. Documents that your employer may have shared as part of an unemployment, workers' compensation, or other legal process. And contact information for former colleagues and supervisors who may be in possession of useful information or who may have witnessed key events. It is often the case that employers give false justifications for termination, hiding their true motivations. These types of information can help serve as circumstantial evidence to prove that your employer is hiding the ball on what truly motivated their termination decision. It is important that you speak with an experienced Iowa employment lawyer as soon as you have been fired. A skilled attorney who specializes in unlawful termination cases can evaluate your situation and analyze whether you have a legal basis to bring a case. To get your free, no-obligation case evaluation, call RSH Legal today at 1-800-433-0283.